record now. So good morning, everyone. Welcome to our live Q&A webinar on employment law updates with Stephenson Law. We are very, very excited to be joined today by Fiona. Just to get a bit of a background, my name is Sanam. I work as an employment counsel here at Employment Hero. And like I said, we're very excited to have Fiona Campbell here today, who is the head of employment at Stephenson Law. How are you feeling? How are you doing today?
I'm good, thank you. Yes, yeah, looking forward to it. I'm sure it'll be a good session, and everyone get ready with your questions, although nothing too hard. It's early.
That is true. It is quite early, and coffee can only go so far in the morning.
Exactly.
But the reason why I'm saying so much that I'm excited to have Fiona here is that it's because she comes with a wealth of experience and knowledge. She has 15 years of experience specializing in employment law, and Fiona is a talented senior solicitor. She's well versed in an array of matters. I know I'm shooting your horn, but you are absolutely amazing when it comes to the stuff. This is her, her area, and she definitely understands how things impact employers and employees alike. Working, I guess, as part of the team at Stephenson Law, I'm sure, Fiona, you've dealt with a lot of cases that have come up that require kind of that commercial approach, as well as being empathetic and understanding what an employer and an employee is going through. So absolutely, the firm, as well as Fiona, they have a high level and a high standard of service. So like I said, welcome, Fiona. We're really happy to have you. And today, as Fiona said as well, we do have a live Q&A session. So we will have time allocated at the end of this webinar for your questions. It is really important to, ask your questions, and please make sure that if you have any, do not hesitate to ask them. Put it in that Q&A box below, and make sure that you can submit them throughout the webinar. Also, you do not need to worry about scrambling and writing any notes. Today's session will be recorded. I know it is a very good thing, and we will be providing you at the end of the webinar with the slide deck, as well as the recording and a couple of other fact sheets and things as well. Now, before we get fully stuck into it, I just wanted to make sure that we put out the disclaimer that, look, this is for information purposes only. We are here to provide this information in good faith. Now, I'm sure some of you that may be watching are employers, employees, and you might be dealing with specific issues in the workplace. And I would highly recommend you to seek legal advice or professional advice around the issues that you're dealing with. I will also have Fiona's details linked at the bottom, on the last slide. And that's where, if you want, you can reach out to Fiona at Stephenson Law and get some more information there. Like I said, it makes a world of difference to get specialized advice around, the issues that you're dealing with. So we'll get stuck into it, and we'll start off with talking about what we're going to be discussing. Now, we've kept the slides quite brief, and like I said, it's because we will be providing a recording, fact sheet, and additional information as well. But today we're going to talk about significant changes that have happened since, unfortunately, 2022, since we did our last webinar. So sorry, it's been a little bit of time, everyone. But in the 6 months, things have changed. So we will be bringing you up to speed on the legislative changes, as well as the changes with the case law and updates around that. And then before we get into the Q&A segment, we'll have one look into, what's coming up in 2023. What are we going to be needing to look out for as an employer and employee? So that kicks us off. And like I said, the last stage of the webinar, we'll make sure that we have enough time to do the Q&A. And so that will bring us in now to the legislative changes. So in the last webinar, Fiona, I know that you did discuss a few pieces of legislation for people to watch out for. And so to kick things off, I want to know if there is anything that has kind of progressed, or if there's any updates that have happened in that area.
Yeah, well, thank you, Sanam, and thank you for that very, very kind introduction. I'm blushing. And good morning, everyone, and thank you so much for joining us today. We really appreciate it. So I'm sure you're all going to have heard of the first piece of legislation that we wanted to talk about. It's been in the news a bit, and that was the Retained EU Law Revocation and Reform Bill. So this was the bill that created initially a presumption that all EU-derived laws would be removed from domestic law at the end of 2023 unless they were actually specifically saved. However, perhaps rather unsurprisingly, since 2022, the government's done a bit of a U-turn on this original plan to sort of sunset, which is revoke, any remaining EU laws that weren't specifically kept on. So now it's sort of the opposite, in that any remaining EU law at the end of 2023 will be binding on UK citizens and businesses unless it's expressly repealed. So rather than automatically being revoked, it has to be expressly repealed.
Or can we expect to see any significant legislation being repealed in relation to employment law? Or
well, yeah, I'd have to say no, not really. So unless you're particularly affected by the likes of the community drivers, hours and working time, road tankers, temporary exception, amendment, regulations 2006. Personally, not really heard of it before. So from my view, no, nothing particularly significant is being repealed.
Okay, and are there any other relevant reforms that are coming up?
Yeah, there's a few proposed changes, but only in minor ways. So it sounds quite significant, but when you dig down, it's not huge. So these relate in the main to working hours, 2p, and holiday pay, which, as I said, sounds really significant. But in relation to the working hours, it's basically removing, or this is the current intention, is removing the record keeping requirement that's under the working time regulations. However, I'm not really aware of many businesses that have been overly bothered with this record keeping element anyway. So I don't think that's going to come as a massive overhaul. And the other significant change was to do with permitting holiday pay roll-up, which is basically normally where you have somebody who's a worker, and rather than being given holiday to take, they just make their hourly rate slightly higher to roll in the holiday pay into their normal hourly pay. But that happens all the time anyway. So it's, again, technically it's a big change, but in practical terms, not particularly.
Oh, no, that is quite interesting, and I think with the changes that have come up, Fiona, you know, we have seen a bit of a shift in terms of menopause in the workplace as well. And we saw last year that the government responded to a report commissioned by the Minister for Employment about menopause in the workplace. Can you discuss what's happened around this space and if there's been any reforms or any discussion?
Yeah, well, it's been a big issue and a lot of talk, but actually initially, so in its initial response, the government didn't really think there was any changes needed, and they felt that the Equality Act was sufficient, basically. But then the Women and Equalities Committee subsequently published a separate report which took a different stance, and they had key recommendations which included in particular enacting Section 14 of the Equality Act. So it's already there but not been enacted, which protects against multiple discrimination. So discrimination that kind of combines two protected characteristics. So in this case, that would say be age and sex, for instance. If it related to the menopause, they'd be the most likely. And then the second recommendation, or main recommendation, which would be huge, was to add a new protected characteristic under the Equality Act to actually give specific protection relating to menopause. And that would include a duty to make reasonable adjustments for employees experiencing menopause. However, and this is the big however, so these were the recommendations. At the beginning of the year, the government did finally actually respond to the committee's report, but basically rejected most of those recommendations, including making it a protected characteristic and even piloting a policy for menopause leave. So we're not really expecting to see any big changes on this, despite it having been quite a big topic. Okay,
and when we did look, you know, at kind of menopause, we saw that a lot of the aspects of menopause, they were looking at flexible working. So what happens if an employee wants more flexible working conditions? Has there been anything?
Yeah, so there has actually been a bit of a change there. So the right to request flexible working has been accepted as being a day one right, and new legislation on this is making its way through Parliament. So we are expected to see a bit of a change there. Yeah, so moving on, you may remember if you were here last time that I finished the webinar by mentioning a number of private members' bills that were actually being supported by the government. So I just want to quickly let you know with what's happening with those before we move on to cases, and to let you know where there's any steps that you should be taking. So the first of these was the Worker Protection Amendment of Equality Act 2010 bill. These things will just trip off the tongue, don't they? This would introduce employer liability for harassment of employees by third parties, and a new proactive duty to take actual steps, so a proactive duty rather than a reactive duty to actually prevent sexual harassment in the workplace. And then if you fail to actually take the appropriate steps, there'd be the potential 25% uplift for failing to take the appropriate steps. So this is currently sitting in the committee stage in the House of Lords, but it is very likely to pass, although we don't actually have a date yet, Sanam.
And you know, you mentioned the positive duty in cases to prevent sexual harassment in the workplace. We did see something similar in Australia that came up in the course of the last year, where it's really difficult for employers because it adds this extra layer where an employer has a positive duty to make sure that sexual harassment is eliminated, or they've put measures in place to make sure that those risks are not exacerbated. So what does this mean for employers in the UK?
Well, practically speaking, I would suggest that you start preparing themselves, and in particular advise, like, conduct a review of your current policies. So for instance, your harassment, bullying, equal ops policies, and any other relevant policies you might have. It also would be worth considering sort of situational training, including the actions that might be undertaken by third parties, and then offering support and guidance for people on how to sort of maybe safely intervene if they see something happening, and giving support to victims. Obviously assessing the likelihood of specific risks in the workplace, because obviously some workplaces it's very, very unlikely to happen, but there's certain places that sort of scream being riskier, such as people who work in a bar, and you may want to look at the different roles and circumstances. So for instance, when you're looking at sexual harassment, you may be more concerned, for instance, or it might be a riskier role, the person that has to go out maybe and collect glasses and is physically almost in contact with people in the public, rather than maybe someone that works, behind the bar, or even in the kitchen or something, doesn't have as much contact with third parties. So yeah, looking at assessing which roles frequently do interact with third parties, in what ways and in what sort of environments, and then take tailored steps to actually reduce the risks. What are the things that you can do? I'd also really suggest consulting with employees on their experiences and what measures they think would be practicable in the circumstances. I sort of say this because I hope this doesn't sound too confrontational, but sometimes you end up in a situation where it's maybe male bosses deciding what's going to work best for their female employees. So it's a good idea to actually engage with the women about what they feel and how they feel it can be done better. Oh, sorry.
I was just going to say, just on that point, Fiona, I worked, as an employment lawyer in the hospitality industry, and absolutely, if employers actually sat down with their employees, then sometimes it does help with understanding the day-to-day of what happens, because sometimes the employers or the directors are not on the floor, or the managers are not there, be behind the counter or something like that. So you're absolutely right. It is great to have that line of communication.
And they may not understand exactly the practicalities of how a task is done. They know it gets done, but they maybe don't understand the way that staff are doing it. On that, it's a good idea to sort of create clear reporting lines so that employees can confidently and sort of safely report any incidences of harassment in the workplace. And then I suppose finally, I'll perhaps create or update, if you've already got it, registers for reporting incidents. You've got a bit of a record, because obviously knowledge is power, and if you know what's going on, it's easier actually to deal with it. So moving on from that piece of legislation onto the Protection from Redundancy, Pregnancy and Family Leave Bill. Again, easy for me to say. This one became law in May this year. So this was something we chatted about at the end of 2022, and it's actually become law this year. And it actually means that from July this year, so the requirement that employers previously had to offer suitable alternative vacancies first to employee on maternity leave. So if you're going through redundancy consultation, there's a suitable alternative. There was a duty first of all to offer that to somebody on maternity leave or shared parental leave, adoption leave. But that's actually been extended to cover the period when the employee is pregnant, from the point that they actually tell the employer that they are pregnant, and through to 6 months after a new parent has returned to work, so added protection for them.
And does that mean that employees can still be made redundant during that period, or does that bar that from happening?
Yeah, no, absolutely. People who are on maternity leave or pregnant can still be made redundant. It does feel, I think, for employers quite daunting because they're aware that there's a bit of a risk, but provided there is a genuine redundancy situation and provided the correct procedure is followed, so they consult properly with the staff and everything. And now, well, as of July, provided that any suitable alternative roles have been considered and then, if appropriate, offered first of all to these people, then it is possible to make redundancies in these situations. But I am conscious that it is a riskier situation. So I would say that that's the type of situation where I'd probably say it might be worth getting advice to minimise your risks. So on the final piece of legislation, moving to the Carers Leave Bill, which actually became the Carers Leave Act in May this year, and it introduces a day one right for people with caring responsibilities. They'll be entitled to unpaid leave of 1 week per year that can be taken in half or individual days. They wouldn't actually be required to give any evidence of that. And in addition, 5 days carers leave each year for employees who do have dependents with long-term care needs. It's all an unpaid right, but employers would be able to give more generous policies or rights if they want to. You know what I mean? They could give it paid and enhanced should they choose to.
Okay. And I mean, just on that point, do you feel like it could create some issues for employers, or do you think that with the fact that it is unpaid, it does give a little bit more leeway to an
It's a lot of leeway, I think, given that it's unpaid. Obviously, there will be some employers who maybe already do give that kind of thing paid, in all honesty. And I think that nowadays we do have a greater situation with different people caring for people, like people becoming carers. I think in particular this can affect women still. So I do think that it's potentially a positive thing to give women that flexibility potentially. And I would be interested to sort of see how many employers do sort of bring in this as a paid right. Yeah, it'll be interesting, I think, to watch, or whether it just ends up being almost fruitless because it's unpaid, nobody takes it, and it almost, yeah, becomes a bit sort of a power, I don't know, a pointless thing to have if nobody's utilising it, basically.
Absolutely. So we'll move on to the case law update. Now, I have heard from Fiona that these are usually the juicier parts of the webinars.
It's always crazy what people will do at work. I'm never surprised.
But there have been some interesting cases where we did go back and forth and we said, should we leave this one in? Oh, it's quite juicy, shouldn't we? Yeah. So there have been several changes that have come up over the past quarter, and we have, as you can imagine, discrimination, things like clashing rights, other areas have been coming up. And so this is where I think, Fiona, we will give a bit of a rundown on cases of note and maybe some interesting ones just to throw in the mix. So if you can, Fiona, give us a brief overview of the first case that's there, and then we'll kick it off.
So for each case, what I'll probably do is try to give a bit of the facts of the case and then give you some advice on how, what you need to take away from it as employers or HR specialists. So the first case is McQueen and General Optical Council. Don't worry too much about the names because they're all there. And this considered discrimination arising from disability, which is, I would say, one of the most common disability discrimination types of claims that we see nowadays. So the facts of this case were that the claimant had a number of different disabilities, including dyslexia, symptoms of Asperger's syndrome, and also partial hearing loss. He had a number of meltdowns at work and displayed a rude and aggressive manner to colleagues. He'd even made a manager cry because of his confrontational manager. His confrontational manner, the manager was not confrontational, the manner was confrontational. So this behaviour resulted in receiving both a verbal and then later a written warning for failing to follow instructions. He wasn't happy with the outcome of this and raised a grievance, and then subsequently brought claims to the tribunal, in particular claiming that he'd suffered unfavourable treatment due to something arising in consequence of his disabilities. His argument was that his inappropriate behaviour was as a direct result of his disabilities, and therefore any resulting disciplinary action arose from those disabilities. So the employer accepted that he had disabilities. They accepted that. However, they didn't necessarily accept that his behaviour resulted from them. His claims ultimately failed. So the ET concluded that his conduct and behavioural issues didn't actually arise because of his disability, but rather because he resented being told what to do, and he became impossible to manage. He appealed to the EAT, but the EAT upheld the ET's original decision. One thing I would point out as a bit of a side note, he did succeed in bringing a claim for victimisation because he'd been treated unfavourably for raising a grievance. So he raised a grievance, they'd been aware that he was already bringing these claims, and then they spent 18 months handling the grievance. And the tribunal described this as unusual and unsatisfactory. And as a result, he was awarded £22,680, which included a 20% uplift for failing to follow the ACAS codes. I think that's worth noting.
And you know, there's a lot of confrontational people and managers, the EAT, ET. There's a lot of information to take in. So I guess from this case, what would you say would be a key takeaway or key takeaways for employers?
Yeah, so what I would say is, first of all, it's important to understand how an employee's disability actually affects their performance and their conduct when they're in the workplace. So in this case, they were pretty certain that they had a good enough grasp on what the symptoms and of his conditions were, and that actually these behaviours didn't result from that. Once you've sort of established what what these symptoms might be and the impact that the disabilities might have, then as we all know, the employer needs to make reasonable adjustments tailored to the specific circumstances to ensure they don't have obstacles whilst working. And I suppose ultimately to reduce the liability on the business. Obviously, if you fail to make reasonable adjustments, that's a potential risk. So here, as I said, because they did have that clear understanding of the effect that the disability had on him, they were then able to sort of differentiate between genuine capability and conduct issues caused by a disability and simple underperformance or misconduct, basically. I would say, unfortunately, although this case is helpful to a degree, unfortunately, it doesn't really provide clarity on the extent to which an employer would be expected to tolerate such behaviour if it were a result of the disability. So here it was found, well, they didn't have to look into that because it was held, he just didn't like being managed, basically, and that's why he was so difficult and confrontational. But I think it would be quite interesting for us if they'd had to look at, well, if they had been symptoms of his disability, to what extent, once an employer's made the reasonable adjustments, what extent are you supposed to put up with that? My view would be that probably it would be similar. It would be a similar outcome, in that you can't really be expected to put up with somebody at work who's maybe destroying the team and, making colleagues cry and things like this. As I mentioned, you have to make reasonable adjustments, which doesn't mean accepting all and everything. But I think it would have been helpful had almost they decided, yes, it was, it was a result of that, and then looked at that. I think that'd be really useful. But it does also, just again, worth sort of reiterating, demonstrate the pitfalls of if you fail to actually handle a formal grievance properly, specifically regarding the amount of time it takes. here they decided that, you know, they dragged it out and weren't dealing with it properly because they were annoyed really at the claims being brought. So he was treated less fairly because they were aware that he'd been bringing claims. So employers do need to be mindful of the ACAS code on disciplinary and grievances, specifically because if you fail to follow them, it can result in an increased award. I mean, here they won really substantively, but they still ended up an award against them of 22,000, which isn't insignificant. Okay, so excuse me. Moving on then to my second case. So this one's Preston and Eon Energy Solutions Limited. And Mr. Preston was an employee of Eon Energy, and he was dismissed following a lengthy absence. Some of the absence was related to a disability. So the facts of this one are that following a prolonged period of absence, Eon obtained an occupational health report on Mr. Preston to establish if he'd actually be able to return to work and if any reasonable adjustments might actually help get him back to work and keep him there. So the report stated that he was actually fit to return, provided that they made adjustments, albeit sort of temporary, and then they would be able to sort of filter them out, you know, phase them out, sorry. And they made all these recommended adjustments, or they were prepared to make these recommended adjustments. And they told the employee this and asked that he returned to work on 27th of February 2018 with these adjustments put in place. He didn't return and refused to come back, and ultimately a disciplinary was arranged and he was eventually dismissed because he basically continuously refused to engage with the measures that were put in place to secure his return to work. He then claimed against Eon and saying that they failed to make reasonable adjustments, and also claimed discrimination arising from disability, because again he's saying my absence was a result of my disability, and then I was dismissed as a result of that. So this arose because of my disability. But the ET dismissed the claims, and they found that the employer had put in place all reasonable adjustments that they could. Once they'd become aware of the condition, they'd obtained health assessments, stress and health risk assessments, and allowed him plenty of time to return from his sickness absence. So the ET found that the dismissal was proportionate given the amount of support that had been offered to him before they ultimately terminated his employment. He appealed, but it was dismissed. And the EAT found that the ET had considered all the appropriate issues, and it was appropriate that they made the decision they made based on the information they had. And this case basically demonstrates that you can actually justify terminating employment in circumstances where the employer has actually put in place significant support to help the individual return to work or remain in work, but there's continued absence. We do get this quite a bit really, where, you know, somebody's off ages and people are quite cautious, rightly so, but cautious about dismissing people when they're off due to disabilities. And I think this case is quite helpful to show, you know, if you've done what you can and they're still refusing to come back, you can actually take action.
Yeah, and I mean, on that subject of reasonable adjustments, I mean, I can see where it can get really tricky for an employer. So are there clear rules on what sort of adjustments are considered as reasonable?
Well, sadly, as is so often the case here, it's the word reasonable is used so much in employment law, but there aren't really any hard and fast rules. And what is considered reasonable is going to differ depending on the individual and their needs, but also the organisation and the resources that it has. So, for instance, the adjustments that potentially Barclays Bank might need to put in place are going to be very different to a small organisation with half a dozen employees, because, you know, what's reasonable for one with the financial resources it has and the people resources and all those kind of things is going to be completely different than what's going to be reasonable for this smaller company. But in this case, it's worth noting that the employer did make sure to undertake lots of assessments to fully understand the extent of the disability so that they could provide proportionate support. So I'd say that's a good start, making sure that before you decide, oh, there are no adjustments, you know, actually undertake an occupational health assessment or get information from a GP, stuff like that, so you can at least go, look, you know, we've taken these steps and we did what we could.
And it's quite interesting to say that reasonable adjustments are proportionate to your size of your business or the type of business that you are. I know in other regions like New Zealand and Australia, it is quite different. So it is quite interesting and quite positive to see that the UK has taken that approach.
Yeah, and again, back to the individual as well, that what might be appropriate for one individual, even with maybe the same condition as somebody else, isn't going to be reasonable for that person. So you'll look at the individual sort of set of circumstances, both for the employer and the employee. Okay, and the next case is quite a helpful one, and this is Randall and Trent College and others. And this is, you know, maybe when we're saying about these juicy cases, one of these things where you're like, the things that people do at work. So in this case, the claimant, the employee, was Reverend Bernard Randall, and he was employed as a chaplain at Trent College, which is an independent day and boarding school. After the school had actually adopted an Educate and Celebrate program, which was aimed at tackling homophobic, biphobic, transphobic bullying, and difficulties they had with attitudes at school. So after they put this program in place, he delivered a sermon which opposed it, basically, and opposed what he described as identity politics, which he said were contrary to Christian teaching. So his sermon dealt with this conflict of values and stated that people didn't have to accept the ideas and ideologies of LGBT activists, his words, where they conflicted with Christian values and should make up their own minds, basically. Not surprisingly, this sermon then led to an unprecedented number of complaints, both from staff and pupils. Disciplinary proceedings then ensued, and he was ultimately dismissed. He then brought claims of religion and belief discrimination, harassment, unfair dismissal, and cited interference with his freedom of belief and freedom of expression. The tribunal actually held that his treatment hadn't actually been because of his beliefs, but because of his objectionable manifestation of them. So that's really important, I think, for employers, that difference between it's not the beliefs, it was how he expressed them. In particular, this was because following earlier sermons he'd given on marriage, sexual orientation and gender identity, the school had actually already told him that these were sensitive topics that should only be dealt with in a classroom setting so that ideas could be discussed and challenged, rather than where he's just, literally preaching at people. But so dealing with them in chapel really risked distress and psychological harm to potentially vulnerable LGBTQ plus students who were maybe coming to terms with their sexual identity at that time in their life. He completely ignored that advice. So they'd already said, oh no, you shouldn't be doing this in this context. He completely ignored that. And he'd actually, and this is the words of the tribunal, he'd given a sermon that was entirely self-serving and not driven by the needs of pupils, to try and kind of persuade them his way of thinking. And on top of that, he'd actually chosen not to share the topic in advance about what he was going to talk about, knowing that he would have been told not to deliver it. So he actually knew he shouldn't do it, and he did it anyway. So it was found that the school had been completely justified in objecting to the way he'd manifested his beliefs, because he'd acted completely contrary to his safeguarding duties and the school's duties to the pupils. So the takeaway for employers here really is this case reinforces the difference between the belief which is protected and how that belief is then manifested, which isn't necessarily. So, an employer can't be disciplined. They wouldn't have been able to discipline him for thinking those things, but they are allowed to discipline him and potentially dismiss him for the fact that, he ignored their concerns and basically, did things that they felt put the pupils potentially at risk. And as a result, their decision to dismiss was found to be fine in the circumstances.
If I was an employer, and I'm looking at how to avoid these kinds of issues in the future, is there anything that you would suggest or recommend would be a good course of action?
Yeah, well, yeah, I would say sort of clear policies, because it's always then useful if you can say, well, look, here's a policy on this and you've gone against the policy, because, you know, that puts you in a clearer position. So if you've got a clear policy that can set out what kind of is and isn't acceptable in the workplace. So in this instance, if there'd been sort of specifically a policy about how you express particular beliefs. So in other kind of contexts, it may be on social media, you know, how you express, because this case is similar to one that I think perhaps we discussed last time in, you know, and so you may want to put in place something that's going to make it very clear, look, you can think what you want to in your own head, but if you're going to go on social media and start saying things that's potentially going to be problematic for us, that's going to lead to problems. So yeah, I think clear policies and consistency is always useful.
And when you Fiona, I was going to say, when you do say consistency, you mean across the board with, I'm guessing, all of the employees and
yeah, exactly. And because then again, that puts yourself at risk if, say, somebody was expressing particular views in a way that, you know, was problematic. So maybe a particular religion, you don't want to have a situation where you're reacting to one person who expresses particularly religious beliefs in a problematic way, but not somebody with a different. So maybe expressing the same views, but from a different angle. You don't want to be inconsistent. So, you know, just try and clarify there, but you wouldn't want to, for instance, discipline the person who expressed certain views because they were Muslim, but not discipline the person who expressed exactly the same views, but because they were coming from a Christian background. You'd need to make sure you can, you know, you applied that completely consistently. Otherwise, you've got different problems going on there. So our second to last case of the day is TX Sierra, I'm sorry about my pronunciation, and Zeka Restaurant, which considers the effect of a pulpy reduction.
Can you give us a brief rundown? I also had to look up what a pulpy reduction was.
Yeah.
What do you mean by a pulpy reduction?
Yeah, so pulpy was a case quite a while ago, so before even I qualified, I think, and it's put very simply, though, it's resulted in a principle whereby if a claimant is found to have been unfairly dismissed due to a failure to follow a proper process, the award can potentially be reduced by up to 100% if the respondent, so the employer, can show that even if a fair process had been followed, the claimant would have been dismissed anyway. It's normally used in redundancy cases because that's the most likely, where it's a situation where we can show afterwards, you know, even if we'd followed a fair process, the whole department was gone anyway, so there was no way it's going to be a different outcome. Whereas it'd be very difficult to show, for instance, in a disciplinary, that you definitely would have come to the same conclusion if you'd not even gone through an investigation process and all these kind of things. So it's much more common in a redundancy case. But in this case, the claimant was a chef and he was dismissed for redundancy, as I mentioned, after the restaurant he was working in faced a downturn during the pandemic. He claimed that no procedure was followed and brought a claim for unfair dismissal. The employment tribunal found that the dismissal was procedurally unfair, and for the purposes of pulpy reduction in compensation, it considered if and when he would have been dismissed if a fair procedure had been followed. And the tribunal found that it wouldn't have been unreasonable for him to have been placed in a pool of one. So he was, say, the only chef, and they put him in that pool of one, meaning that there was 100% chance that redundancy would still have occurred when it did. So they've decided, right, there's 100% chance that he definitely would have just gone when they dismissed him anyway. And as a result, his compensation was reduced by 100%. And he appealed to the EAT. The EAT actually allowed the appeal, and they found that the possibility of a pool of one being fairly chosen, so him being the only person in that role, didn't necessarily mean that the dismissal was bound to take place when it did. They found that on a proper application of the law, the employment tribunal should have considered what this particular employer would have done if it had acted fairly. So the ET's reasoning hadn't taken into account, for instance, the general requirement for some warning, some consultation, and both of those things potentially could have resulted in a larger selection pool, or could have resulted in a change in selection criteria if that had become relevant. And they also mentioned that even if the dismissal was actually inevitable, it might have been delayed. So even if it was 2 or 3 weeks later, because they'd had to go through this process, that could still have resulted in some compensation being due to the employee to account for those 2 or 3 weeks that he would have still been employed.
That is absolutely crazy. Does this mean that you know, as an employer, I should be reacting by saying, look, this is my get out of jail free card.
Well, yeah, I mean, my view on this is that, like, getting 100% bulky reduction isn't necessarily that common, but also relying on, as you said, as a get out of jail free card, it would be a risky thing to do. What I'd say is it can be a really useful negotiating tool, because if you can say to somebody that you've dismissed, look, yes, we maybe didn't follow proper process, but we're really confident that we're going to be able to show, look, this department is completely closed. So you definitely would have gone in any event. You might have gone in 3 weeks, so therefore we'll just pay you 3 weeks pay, you know, when you're negotiating a settlement or something like that, rather than, yes, you would be expecting to get a full, you know, several months compensatory award from the tribunal. And it can obviously be a bit of a safety net. It's definitely something that you use in a worst case scenario. You know, if we're found to have unfairly dismissed, there is the potential of the polky. But I wouldn't advise it as a way of getting out of going redundancy consultations by going, oh, well, we know even if they bring a claim, because firstly, you know, getting to that point is very expensive. And it's a lot of time, so you don't really even, you've still lost in a way if you've had to go all that way. And even if you get the reduction, you've potentially spent tens of thousands on like legal fees and all the time that you've spent dealing with that. The other thing I'd mention is you certainly shouldn't be thinking like that if there's the duty to collectively consult, because then the potential ramifications are even more serious. I'm a little bit conscious of time, so I'll just try and fly through the sort of last case that we've got here, which is Mika. And this is considering the importance of clarity when it comes to dismissals and also timings in unfair dismissals. So in this case, Mr. Mika was a manual worker and he'd been off sick for an extended period. Following some conversations regarding the possibility of a settled exit, he was sent a letter by his employer that he received on the 7th of February. It was headed without prejudice, so an off-the-record letter, but within it said that there was going to be a mutual termination and his last date of employment was going to be 7th of February. It offered him an ex gratia payment if he signed up to a settlement agreement, but he didn't sign it. The letter was then followed by payment on a week later on the 14th of February, and he was told that this was his pile-on and holiday pay, basically. He then brought an unfair dismissal claim because he'd not signed up to the settlement agreement, so he's able to bring the unfair dismissal claim. And the employer argued that the effective date of termination was the 7th of February, and he argued it was the 14th. Now, this is significant because if it was the first one, his claim is out of time, but if it's the second one, the date he says it was, his claim is in time. He argued, so Mr. Mika argued, that the letter was just a without prejudice offer letter. It wasn't actually a dismissal letter, so it couldn't terminate his employment. The tribunal held a preliminary hearing, so an early hearing, this wasn't at the full hearing, to consider whether the claim was presented in time. And it considered whether a without prejudice letter could be an effective dismissal letter. And it decided it was, and he appealed, Mr. Mika appealed, saying he thought it shouldn't have been. But the appeal was dismissed, so the EAT agreed with the employer. They found that the effective date of termination was the date that he received that letter. They found that whilst the letter was wrongly referred to a mutual agreement, because he's obviously hadn't mutually agreed to terminate his employment, it didn't undermine the fact that there was clear and unambiguous wording in there. And it confirmed that his employment was to terminate on a specific day and set out how he would be paid and what he was going to receive because of the termination. So even though it was marked without prejudice, the EAT found that the tribunal had been entitled to read it, basically this without prejudice letter, as having an open, so sort of public section of the letter that set out the termination arrangements, and then a second without prejudice section concerning the settlement agreement. Now, what I'd say is, although this was decided in favour of the employer and the employee was found to be out of time, it should be noted that clearly this created a lot of fuss and faff because there wasn't clarity around a dismissal letter. And ideally, a termination is going to be clear and unambiguous and shouldn't be within without prejudice correspondence. I'd suggest keeping those two things distinct. So you can send a dismissal letter and beside it, you know, attached to the same email, you can have the without prejudice correspondence, basically. And
are there circumstances where out of time claims are just going to be like, yep, these are good to go?
In unfair dismissals, so straightforward unfair dismissals, it's quite rare. You can get an extension, but a claimant needs to show that it wasn't reasonably practicable for them to submit it in time. This is interpreted really quite tightly and in effect means that it wasn't practically possible to submit it. But in discrimination claims, the chances of extension are much, much higher, because then the test that it needs to satisfy is whether an extension is just and equitable, which basically means, is it fair? And they'll balance the interests of the parties to decide, is it fair to allow it? You see them most often in disability discrimination cases because people would argue they weren't well enough to submit it. And in a lot of cases, you will see extensions being granted. Right, so we probably have overwhelmed you quite a bit with all this case law, but thanks for bearing with us anyway. And
we'll have a look at things to look out for, Fiona, for the rest of this year. I am a bit mindful of time, so we might take a breezy approach and go through this quite quickly, if that's okay, Fiona.
Yeah, I'll just clatter straight through then. But basically, just very quickly, the first thing to watch out for is this private members bill on whistleblowing. It's just going to give broader powers to punish punish people who don't deal with whistleblowers properly. So employers who fail to protect whistleblowers, there'll be greater punishments and potentially fines and things, and this would repeal the existing. That's still in the very early stages of the House of Lords, so it's probably going to be some time before it would come to fruition, but it'd be good to be aware and just keep an eye out because you may need to tighten your whistleblowing policies. And then we've got the non-compete clauses. Just very, very briefly, the government is considering restricting non-compete clauses to 3 months. Again, it's a while away before this might happen. But I'm already sort of mentioning this to clients because obviously when people are saying how long should my non-complete clauses be, you know, what's going to be viewed as reasonable, bear in mind if the government's likely to be bringing in legislation saying they can't be more than 3 months, then having them that last 6 or 12 months might be more difficult to enforce. And yeah, speaking at a great rapid pace here, but finally another case. I know you're completely sick to death of cases, but one last one that we just mentioned because it's quite interesting because it raises AI, and AI is everywhere at the moment. And in this case, this was Manjang and Uber, and in it, Uber had used facial recognition software to recognize drivers, so they could sort of log in, and basically it failed to recognize some drivers of ethnic minorities, which had basically precluded them from then getting work. So we're still waiting to see what happens with that, but it's an interesting case in terms of the use of AI in work and the problems that it can cause, basically.
Perfect. Oh, wow, you breezed through that.
I did really breeze through. I'm very conscious of time.
Really
No, we do want to have a bit of time for Q&A, so sorry about that, guys, if that's very, very fast.
No, that's all fine. And like I said, we will be providing some information along with this as well as the recording. So this will take us into our Q&A component, which I'm sure a lot of you are here for. I can see that quite a few questions have come in. And I thought we'd just get stuck into it, Fiona, if I can rattle them off and you can, take a gander at doing them.
Yeah, I can't see them, so you'll just have to.
Yeah, that's fine. So one of the questions we got is quite specific, but I think we can make it a bit more of a general one. It is about, an employment agreement saying that a salary is paid at a certain frequency, so it's paid on a monthly basis. If an employer wanted to change this, what process would they have to undertake? Would it be a variation process, or how would
that's quite interesting. So if they wanted to go from paying monthly to weekly, something like that, for instance, I would imagine that this doesn't come up that much actually in terms of changing the regularity of paying. I would expect that if you're moving from paying less often to more often, it would be less problematic, because people would then should still have the money there when, you know, it comes to the time to needing it. But if you've been going from weekly through to monthly, that might be more difficult because people maybe are relying on getting money weekly. What I would say, and I say this nearly all the time for these things, is the first thing, talk to people and try to agree something, because you may find that, for instance, if you're moving from weekly to monthly, that you might be a lot of people who are like, oh, thank goodness, because I pay everything monthly anyway, and it's going to be much, much easier for me. So you might find, right, we've got all these people and this many have already said yes and signed up to it. The ones that aren't happy, try to find out why, because it may be that you can offer, in that particular case, that you can offer some support. So like a bit of a bridging situation, because until they get up to the point where it's all on an even keel again. So you might be able to provide support to then, okay, and now you've gone from these many and these have agreed, oh, now these ones have too, and you're left with less and less people who disagree. If there's certain people who can't or who refuse to agree, and it is something you need to do, because I'm going to imagine that you can't really have a situation where you're paying some people weekly and some people monthly, then you'd maybe need to go through a sort of more formal consultation process. So in which case you need to have things like your business case properly ready to explain why you need to do this. You need to have meetings with the staff where you discuss the change and why you're bringing it in with them. And again, you try to seek their agreement, and hopefully somewhere through that consultation, you do get their agreement. But then if at the end of that process, they still are refusing, you may need to do what's known as a dismissal and re-engagement, where you basically dismiss them on the old terms and then immediately, you know, at the same time, offer them a new job on the new terms with the new payment date. Now, this is kind of assuming that we consider this to be considered as a substantial term in their contract when they're paid. It may be that we can try to argue that, look, this isn't a significant change and we can rely on the clause in our contract that allows us just to vary the terms, you know, by sending notice and saying, look, within a month or whatever, we're going to change this. You could take that approach. The risk is that somebody says, no, I think this is a breach of contract, I'm resigning, this is a constructive dismissal, I'm now bringing an unfair dismissal case. So that's the risk there. If you go through the dismissal and re-engagement and you've gone through the full consultation, it's not totally risk-free, because obviously you've still dismissed someone, and if they then don't refuse to accept the new job, effectively, there's been a dismissal, you know, and you could get a claim. But I think if you've followed all the steps properly and you've shown why you need to make this change and why it's important, and it's not just, oh, well, it might be slightly easier, there may be real financial reasons that you need to do this, or real business reasons, then I would say that would put you in a pretty strong position.
That's good to know. I had no idea about kind of the risk that could come up, and I didn't even know that you can do the termination or the dismissal and then the rehire.
Yeah, dismissal and re-engagement, although you have to be quite careful with those, but because you sort of feel like all you're doing is changing the terms, but technically speaking, there's still a dismissal there. So if you're thinking of doing something about that, I would normally say it's a good idea probably to get advice on something like that, because it might seem minor to you, but if you've got somebody that has everything, their life set up on this basis, it might be quite difficult for them, you know. So I think it's just being understanding as well of your staff and their needs.
Right, that's good to know. I think that's definitely something important for employers to look out for on a day-to-day. And in terms of some of the questions that have come in, they've come around the worker protection, you know, kind of a topic that we spoke about. And some people asked about the proactive steps that would be, you know, needed by, or, you know, utilized by employers. Would training be a part of that? Would that be something that would be recommended to provide?
What was the context of this? Sorry, the protection.
But for the worker protection, I'm assuming it's relating to the sexual harassment or the positive.
Oh, sorry. Yes, of course. Sorry. Yes, definitely some training. I think almost like scenario type training would be really helpful, so that people understand what to do in certain circumstances. absolutely training, and yeah, policies in place. And I can't emphasize enough, though, it's really important to listen to the staff and their worries about these things, because, as we said before, the way that you think things are happening might not be the way things are happening in reality, and the risks that people face might not be what you think or you would have thought was going to be the main risk. So do sort of listen to them. But yes, I would certainly say, especially as this would be creating quite a different sort of thing, and because you've got a proactive responsibility, you know, that if you are just sort of going, oh, here's a policy, and you just hand over a policy to people, and now it's back to them to make sure they're complying with it, or make sure, you know, that they do what they need to do. I think having a proactive duty, doing something then concrete, where you're like, right, well, we had a half day's training on the policy, but also on steps to take. And I think, as I mentioned, like, when is it appropriate? What should you do if you see something happening to a colleague? What steps should you take? And I think things like that are all, you know, more, it's going to help you show that you've actually been proactive rather than just throwing a policy at the situation. You know, I think the more that you can, and if you show, like, getting people to sign something to sort of say that they've received this half-day training would go to some steps, I think, towards showing that you've actually practically tried to do something. You've actually taken steps to minimize the risk to your staff, which is the important thing.
And we've had some questions come up around carers leave. So one of them is when the carers leave will take effect, and another one that's related to it is there a difference between dependent leave and carers leave, and can employees take both?
Yeah, I'm not sure. I need to come back to you on when it's actually coming in, so apologies about that. But it is different. So the two things are different. So this is something that you'd be entitled to, and you could book it in advance and say, right, I'm going to need time off for this particular type of leave. Whereas, as you may well know, the dependents leave is where you need time off for emergencies to take care of a dependent. So it's not something you can book a week in advance. It normally is something where you're, you wake up that morning and your kid can't go to school, so you've got to ring in, and I need to take a day off for dependents leave to look after my child. Whereas the carers leave, my understanding is it's more something that you can actually say, right, well, I'm going to want to book a day to do this with my child, or to look after this person that I'm looking after. So I think it's quite different. So one's just in case of emergencies. It's also unpaid, although again, I know that lots of public sector employers give up to 5 paid days of dependents leave a year. So I'd be astonished if they don't adopt the same approach with the carers leave. But no, they are different and would be used in different circumstances, I would say.
Right, perfect. No, I think that's exactly what we were kind of looking for. And one of the things that came up was around whistle blowing and the policy around that. Somebody's given a hypothetical in terms of having, a small company, maybe 200 employees, and whether a company or of that size, or maybe any other size, should have a whistleblower policy. Do you have any ideas around that?
I would say yes. Even now, I would be saying yes. It's always a policy that's advisable, and it's looking like, now there's not been that much details about this bill, to be honest. I was scraping around trying to find out, and all I can really find, I think, maybe unless you go into it and read it all in full detail, which, snooze fest. But anyway, I think the main thing is there's going to be more penalties on employers who fail to kind of look after their whistleblowers. I think fundamentally, from what I could get from this, it's that actually it is whistleblowers that have reported or uncovered wrongdoing, in organizations in the workplace. And so they want to afford greater protection to these people who are kind of effectively helping society by uncovering these issues. So yes, I definitely think you will need to do that if and when this comes in. But even now, I'd be advising it's a good idea. It should be part of your handbook that just sort of sets out, but first of all, like, how does an employee blow the whistle, and explains the protection that they'll have, because people need to then I guess, understand not only, well, I don't even know, I know this is going on, I know it's not right, but I've got no idea what I'm supposed to do with that. But also I don't know what will happen to me if it does. If I sort of tell my line managers, say, I don't know what might happen to me afterwards. Whereas a policy that sets out the protection that you've got and that you shouldn't suffer any detriment for raising, you know, for blowing the whistle, for raising these issues, would obviously be sensible and would encourage people to blow the whistle, which is really what they're supposed to be there for. And I would like to think that ideally, all you nice people, you don't want to have a wrongdoing going on in your workplace. You want to make sure that if somebody's behaving inappropriately or cutting corners in ways that isn't right, you want that to be, you know, you want that to be uncovered so that you can deal with it and make sure things are being dealt with appropriately. And having a strong sort of whistleblower policy that, as I said, explains how to blow the whistle, but what protection they'll get is a really good idea to help with that.
I can really see the benefits with it, especially if the space is changing quite a bit as well. So we do definitely you know, have quite a few questions left, and we will try to get to them.
Can I just butt in there? Sorry, Sanam, I did notice, I found the questions now, and I did notice that one of them mentioned this Earl Shilton case. We did decide not to cut it out because it wasn't really giving anything particularly new. It was just a case that said that you should offer the similar facilities to your male and female staff. It was just kind of a bit of an amusing aside in the middle, but we've still left a link there, so if you're interested, you can take a look. So apologies for that. I know it's a bit misleading that we've just missed it, but there's a link. You can have a quick look. It's quite funny from my perspective. I thought it was quite amusing, but yeah, we just felt time-wise we needed to cut something today, so sorry about that.
Some people say misleading, others say it's building anticipation for reading the
case. Yeah,
case.
Exactly. A bit mystery. You never know what you're going to get. Sorry about that though, guys.
No, that's fine. So like Fiona said, you know, we will have the slide deck available with the links, as well as a recording and a fact sheet. So thank you everyone for joining us today. You know, we really hope that you found this useful. Thank you so much, Fiona, for being here. Amazing amount of knowledge. Like I said, I didn't oversell, guys. See, I was, you know, telling the truth. Just to keep in mind, a survey will also pop up and launch after we end the webinar. So please, if you can take the time to fill it in, it'll give us some feedback as well on what we can improve on, or what other things that you've liked. And like I said, we will send out those additional resources as well. You know, thank you so much. If you have any specific questions about a scenario that you're dealing with, absolutely, please reach out to Stephenson Law. And like I said, we've got those details in these slides as well. So have a wonderful day, everyone. And thank you so much, Fiona, for being here.
Thanks ever so much, Sanam, and thanks again, everyone, for coming. I really appreciate it. Thank you.